Good morning, friends. I, CAIP Harinam Agrawal, IBC Amendment Bill and recent landmark judgments. For this, I invite none other than Advocate Sumant Batra, Insolvency lawyer, on the dais.
Very good morning to all of you, Honorable Justice Seshasai, member of the National Company Law Appellate Tribunal, senior officials of IBBI, Mr. Gyan Chandra Mishra ji, the leadership of the Eastern Chapter, and my esteemed colleagues here. It's always a pleasure to be back in this hall. It's probably my fourth or fifth talk from this very stage. And I'm always very impressed and amazed by the enthusiasm which all of you show in terms of learning and the developments in insolvency and the related areas. Now, we all know that the bill, the Insolvency and Bankruptcy Code Amendment Bill 2025 was tabled in the Parliament on 12th August. And many of you might know that this is something that has been long awaited. The discussion for the various amendments, the various policy changes, the various modifications in the law, all were expected in 2024. And in fact, the discussion on that started even a year before that. A discussion paper from the Ministry of Corporate Affairs was floated. And many of these changes that you see in the bill were those that were proposed about 3 years ago. But it took a long time for a variety of reasons, and I'll come to that in a moment. Although belated, but when implemented, or even amended for that matters by way of the Parliament accepting the bill, which we hope will happen in December or early January, it is going to propel Indian insolvency system amongst the best in the world. But, from my prism, these changes don't need to be viewed from a micro level. They have a much greater significance, and I will outline those as I share my perspective of what the bill is all about. But I must say, before I start talking about the various aspects of the bill, that what it does largely is open the doors for us to start walking the path of achieving 8% GDP growth or around that, which is what we need as a nation, as an economy, to fulfill our aspirations to become a developed economy by 2047. And that for me is perhaps the most powerful message that comes out of the changes that are proposed, and I'll also share how. I see the IBC Amendment Bill modifications through 5 different buckets. The first bucket actually contains the fulfilling or filling the many policy gaps that have existed since 2016, when the IBC was introduced, or for that matter, which ought to have been filled on the way over the last 8 to 9 years. The second category is implementational gaps being addressed. And the third category is addressing areas where the market failed the policymakers on the regulator. The fourth category is where you might have some disappointments with something that didn't come through in the bill, or the provisions might be troublesome. And the fifth, in my view, is the overall objective that is thought to be achieved, besides these four, but as a combination of these four. Let me just start with the first one, the policy gaps. There are three major policy gaps that are sought to be filled through this bill. The first is the cross-border insolvency. As you've seen, that there is a provision, a substantive provision, an enabling provision, which makes way for the cross-border insolvency framework to be introduced, but by way of subordinate legislation at an appropriate time. Now, this was something which has been expected from 2017 itself. In fact, when the bill was tabled in the Parliament in 2015, and it was referred to the Joint Parliamentary Committee, Mr. Bhupinder Singh Yadav was the chairman of the JPC, and at that point in time, I, and of course I'm sure many of you might have presented themselves as a witness before the JPC, and obviously one of the things that we pressed on the JPC was the need to have the cross-border insolvency framework. And the JPC in its para 23, if I remember the paragraph correctly, in its report, did recommend that given India's geopolitical positioning, its economic aspirations, it wanting to offer the best standards in the insolvency industry, it is inevitable that we have a cross-border insolvency framework in the proposed bill. At that point in time, there was an immense urgency in introducing the IBC as soon as possible, and it was felt that it may not be possible to go back to the Bankruptcy Law Reforms Committee and ask them to propose a framework, because that would have taken another 4 to 5 months. And there was already a great urgency. And that great urgency, I'll pause here for a minute for the benefit of those who may not be aware of some of the developments in that time. In 2014, when the government was formed, our GDP was down to about 4 to 5%, even less by some people, but certainly about 5 to 6%. It had dropped over the last 5-6 years from 2-digit to about 5 to 6%. The non-performing assets in the banking sector had reached a stage where the banking sector was on the verge of not just a crisis, but a collapse. The asset quality in the banks, of the assets that they held, had degraded to an extent where those assets were losing any productivity that they could offer to the market, to the GDP. The twin balance sheet problem was at its peak, the whole evergreening of the loans, as you know, and the window dressing of the balance sheet by the banks themselves. And when Prime Minister Modi visited US, as you would recall, that was the first overseas trip that he made after taking over as Prime Minister. There he met IMF, the World Bank, various multinational corporations, various investment banks, the top ones in fact. And he invited them to come and invest in India. Now that there was a majority government, there was a fresh energy and hope in the economy. The question that was put to him was that all that is fine, but where is your insolvency law? Because for all global investors, exit law is as important as the entry law. When he returned, he immediately therefore spoke to Mr. Jaitley, the finance minister, and he said that we need to introduce insolvency reforms on priority. That is what led to the formation of the BLRC. So the combination of the two, where the investors globally demanded that insolvency reforms be undertaken on top priority, and also the banking sector itself being on the verge of crisis, they being lacking capitalization, there was no money to circle back into the economy by the banks because all of their money was locked in non-performing assets. There was a dire urgency to introduce the IBC, and therefore the government couldn't afford the luxury of another 6 months. At that point in time, Mr. Jaitley was able to persuade the JPC that let us, for the time being, address the issue of cross-border insolvency by introducing 2 provisions to whatever those 240, whatever 47, 48, whatever those provisions are, to enable bilateral agreements with different countries in the event the need arises to have cooperation with those jurisdictions to deal with cross-border issues. That was a stopgap arrangement. But immediately after that, Mr. Jaitley called Mr. T.K. Vishwanathan that we need to have the cross-border bill introduced as soon as possible. Mr. T.K. Vishwanathan and I drafted the cross-border insolvency bill, gave it to the finance minister. He passed it on to the secretary MCA. Then Joint Secretary MCA had a meeting with us, and that bill was prepared by us with full market consultation. It was a complete sign-off by the entire industry. But there was a feeling in the ministry that we should first consolidate our domestic law. It's absolutely new, brand new concept, and fair enough. And it may not be an appropriate time to introduce the cross-border insolvency law because we still really haven't cemented the new principles that are sought to be introduced by the IBC, and the market needs to be built awareness about that, prepared to implement the municipal law first and then go to the cross-border law. So it was held back for some time, but because the pressure kept coming in and our scoring of the ease of doing business ranking couldn't reach the optimum level because we didn't score good enough on the cross-border insolvency, the pressure was on the government to enact this law. It was also for the reason that it was experienced in many of the first 40-50 cases that came in, which actually constituted about 50% of the total NPLs in the big books of the companies, where there were a large number of enterprises that had assets abroad, or the creditors abroad, and the RPs could not reach out to those assets, and therefore we could not maximize the value of the enterprises or the assets underlying those enterprises. Eventually, we all know that Part Z was proposed, but I guess at the policy level, there were some difficulties in persuading them to incorporate Part Z as proposed in the bill, and therefore we've been waiting for the last 2 years for that to happen. But in the last 2 months or 3 months, since March in particular, some very rapid developments took place at the highest level of policy making in the country, where eventually it was agreed that let's introduce the cross-border insolvency law, but perhaps in a shrunk way, where we just incorporate the enabling provision, and then at an appropriate time, we introduce the framework by way of subordinate legislation, the rules that of course would be tabled in the parliament. And if you see the bill, not only there is an enabling provision, but there is also a subsection that follows, which provides that each rule that will be prepared to provide the framework for cross-border insolvency will be tabled in the parliament. Even though there is a general such provision exists in the IBC framework any which ways, but it was thought appropriate to have a more specific provision with regard to the cross-border insolvency. That's one. Now, one more comment on the cross-border insolvency. If, as and when it is introduced, and I'm hoping this will happen in the first part of the next year, this will really position India amongst the best in the world. The entire global fraternity has been waiting with held breath for India to enact cross-border insolvency law, because it is expected that once India, as the voice of the global south, implements, a number of other countries who are waiting for India to adopt and show the path will adopt cross-border insolvency law, and the number of countries that have adopted the cross-border insolvency law will rapidly rise from about 55, 56 to 3/4 of a century. And of course, there is an expectation that even China might therefore be compelled to match India and introduce the cross-border insolvency law, because amongst the major economies in the world, it is only China and India that have not adopted so far. The rest have. The second policy gap that is sought to be filled is group insolvency. This again has waited too long, painfully in fact, painfully long. When the first 12 cases were introduced into insolvency in June 2017, at that time itself it became very clear that we need the group insolvency law. Amtech Auto Limited, Videocon, JP, Infratech, and of course Jayaprakash Industries, which faced where insolvency started last year only, but we all know that it was part of the first 12, and then of course in the subsequent 24 that came in. Many of these cases involved companies that were either subsidiaries or part of the group, and they all actually, for example, let's say Videocon, with 13 companies went into insolvency. RPs were appointed for 3 each. So one RP for 3 corporations, different NCLT jurisdictions. The holding company actually was the one that had the trademark, did the sales, did the marketing, but the manufacturing of most of the white goods was done by different entities. But for all intents and purposes, they were one single economic unit. And yet, you had different RPs pulling it in different directions, different COCs taking different line of directions, and eventually, we all know that, in fact, I was advising the RP of the holding company, and we went to the chairperson of SBI, which was the lead bank, to say that this is not going to go anywhere unless you try the consolidation, at least procedural consolidation. There was a reluctance because there was no policy. And for a public sector bank to take a step of filing an application and seek something which was not a part of the policy is not easy. But the SBI chairperson at that point in time was persuaded, an application was filed, and we saw a procedural consolidation order being passed by the Bombay NCLT. And at that point in time, of course, IBB has set up a working group which did recommend eventually to the government that there should be procedural consolidation. That was all in 2018, 19, 20. And finally, therefore, we've seen that manifesting in the form of, again, a set of provisions in the IBC bill, where though it enables largely the Ministry of Corporate Affairs to frame rules, but many substantive provisions, unlike in the cross-border insolvency case, have been added as a part of the bill, largely because of the reason that it is a bit sensitive, because every committee of creditors has its own individuality under the law. There are the whole, every COC has a right to appoint its own RP. And in the wake of those provisions, it is important to have substantive provisions in the law itself to provide for certain basic provisions for coordination and cooperation, rather than it being left only to the rules. Now, the group insolvency and the procedural consolidation that we see is again something which doesn't even exist in most sophisticated jurisdictions as the provisions of law. It has evolved as a good practice, best practice, and in a very advanced way. But in many jurisdictions, you don't really have substantive provisions in the law for that. So therefore, in that sense, it is a big leap forward for even India. The third, which I believe has a great significance for the fundamental approach to insolvency resolution, and I also see it as a big shift in the policy, is the creditor-initiated insolvency resolution process, which in common parlance is known as pre-insolvency resolution. Pre-insolvency resolution has been a norm in many advanced jurisdictions for now about 15-20 years, and it is called by various names, pre-pax or other kind of names. In fact, Chapter 11 in the US is nothing but a mix of pre-insolvency resolution and a formal resolution, because there also, even before a Chapter 11 is filed, most of the times the resolution plan is pre-agreed with the lenders and with the debtor, so that the filing of the resolution plan is not a surprise to the stakeholders, and the shock is softened to those at least who are not part of the negotiation earlier, because then they know that the majority have already agreed, and only then you file a Chapter 11 invariably. After COVID, pre-insolvency resolution has become a norm worldwide. In Europe, in fact, it is considered to be the first choice by the stakeholders. So, from the Indian perspective, yes, of course, it will go a long way in reducing the workload of the NCLTs, because the knocking of the doors of the NCLTs will only take place at the time when the plan is ready for approval by the NCLT and an application is filed. You don't need to go to NCLT before that. Most of the activity will happen in the shadow of the law. Of course, under a framework that will be provided in the subordinate legislation, and to the extent it is already provided in the IBC. But to me, the headline out of this is that this is a very big window opened for honest promoters who have not lost the trust of the lenders, but maybe in default, or where the trust deficit is such that it can be easily bridged by taking some corrective measures. And in a way, therefore, it sort of introduces the concept of debtor in possession in the IBC. And the reason for that is, and the cue for this was taken when Finance Minister in her speech on 1st October, I think it was 2023, she mentioned at the IBBA Foundation Day that we need to take measures to prevent the erosion of value of the assets of the corporate debtor at the first possible instance. And we all know that the erosion starts as soon as the asset becomes non-performing and it is imminent that an insolvency will be filed or some recovery steps will be taken by the lenders, and the promoter starts losing interest, especially after the IBC has come into being, because he knows that he'll go out. He will no longer be in control of the management, and therefore he is now only looking how to protect his own interest. And lenders still may take 6 months, 7 months, 8 months to file the insolvency process. All this time, there could be potentially avoidance proceedings taking place, avoidance transactions taking place. And then, of course, a major disruption happens when a petition is admitted and RP is appointed, and therefore RP has to take over the enterprise from the promoters and then try to stabilize it, learn about the business, and ensure that he tries and preserves the value to the extent that he can. And then, of course, this whole disruption continues because there may not be enough resources available for him to run the enterprise as a going concern. He may not even have the resources to hire the right kind of advisors needed. Promoters stop cooperating. It may take 1 year, 2 years for a resolution plan to happen. And even if a resolution plan is approved, you still have a monitoring committee keeping a watch till such time as a stopgap arrangement, but till such time the plan doesn't start getting implemented. And then the handing over to the new management takes place, which is the successful resolution applicant. In the length and the breadth of this whole process, various disruptions take place. And if we can still find cases where the creditors and debtors are able to work together, there are no malpractices, there are no allegations of fraud, then why not give the promoter a chance? I just want to make a brief point here, and please indicate to me whenever my time is running up. Just let me know about 5-7 minutes before then. And the roots of this from in the Indian context are very important. You see, when we introduced the creditor in control or possession law, it was a big departure. In fact, a leap from one end of the spectrum to the other, from SICA to this. Fair enough, we needed it. We needed it at that point in time, at that stage of the economy. But the fact remains, our major trade partners do not necessarily come only from those jurisdictions where there is a creditor-friendly insolvency law. Globally, as you know, that the world is divided into two broad frameworks of law: debtor in possession and creditor in control. Debtor in possession is led by the US, creditor in control traditionally has been led by the UK, particularly since 1988. Those countries who trade in a big way or are dependent on the US for trade, something that is emerging as on the surface with the whole tariff issues coming in the last 6 months, they obviously prefer a policy that suits their investors, who are comfortable with a particular policy and approach. So we shifted from a US-based model under SICA to a UK-based or inspired model. But our major trade still aspirationally is going to be with US, Japan, and many other such countries which follow a debtor in possession philosophy. About 3 years ago, when the tariff tension started between US and China, while in India it was still confined to Harley Davidson, and the US was pressing on India to relax the tariff. This was about 4 years ago. We hadn't really seen this kind of major headlines coming on the tariff. But this had started to build with China about 3 years ago. And at that point in time, there was a paper in the Prime Minister's office, which I had presented. And one of the issues that we had identified at that point in time was that if this tension between US and China escalates and US companies start pulling out of China, they would start looking for alternate jurisdictions to invest in. They would obviously make a choice of those jurisdictions where there is a debtor in possession law, at least in the first instance. While India is completely unavoidable, we are a big market, and any country would want to invest in India, in terms of their corporations. But the fact remains, they then evaluate their risks. US corporations are not used to a system where one operational creditor files a petition for 1 crore default and a multi-million-dollar company would have its shutters being pulled down. They can't expect, and above that, then you have a Section 29A, where then the management cannot even bid. So for them, it is a bit alien and shocking. And rightly so, therefore, you would have seen that many of these corporations that pulled out of China went to Indonesia, went to Vietnam, went even to Cambodia. When Sri Lanka went into a major disaster and the IMF negotiation happened, US, various countries took the responsibility, primarily US and Australia, which funded a lot of reforms. And US undertook to support it on the insolvency reform. And they appointed two lawyers as a consultant, US lawyers as a consultant, to advise on the insolvency reforms in Sri Lanka, and they proposed a Chapter 11 model. Because that's how global diplomacy works. If they want their corporations to invest in a country, they would want a familiar law. But I don't want to go into that Sri Lanka thing more in detail. I mean, that's a conversation for separate, because we were able to persuade Sri Lanka to look at different models as well, and particularly Indian model. Now, in my view, this pre-insolvency resolution provision has a great significance, because it's a very powerful message to the global community that yes, even debtor in possession law is there, and for those corporations that have not lost the trust of the creditors, you still will be able to negotiate a resolution plan, in fact, without even going to NCLT. And therefore, there's no risk or threat of you being thrown out of the management or 29A standing in your way. Although, even in this process, you need to have a 29A compliance, but we are expecting that in these cases, the entire exercise and the machinery will set into motion as soon as the default has happened, or even before that. Because when it is clear to the debtor and the creditors that the default is imminent, they will start this exercise, especially when they know that this is the debtor that they want to continue to work with. So this is a major headline, and I think that's the narrative that we need to build for the benefit of the global community, which feels that there's no space for debtor in possession at all. This is the first bucket. The second bucket is more predictable, is perhaps something which can be read in the bare, plain reading of the bill, that what it does to do is address the implementation gaps. We all know that in law, a gap opens up between the law on the book and the law in practice. And that's exactly what has happened. We've been addressing these gaps over the last 8 to 10 years by legislative changes, by regulations. But it is, even 10 years is too short in the life of a law as important as insolvency law, and therefore it is not surprising that we still continue to face insolvency implementation challenges. But to me, these challenges on the implementation are not as much on account of the gaps in insolvency law, which have been filled to a large extent, but also are on account of the cultural conflict. When I had published the first edition of my book in 2017, when the IBC had just come in, the last chapter, about 20% of the book was on implementation. And I spent a fair amount of words talking about the major behavioral change challenges that we will feel as we implement the law, not only because we are making a major policy shift of debtor in possession to the creditor in control, because you can change the law, but you can't change the way people do business in India or have done business for centuries. Number two, we have to realize that we are introducing a very sophisticated free market law in an economy which was at a very nascent stage of free market, which in fact is still in the shadows of a closed economy, because we may have laws that are meant for free market economy, but our behavior within the policy making, bureaucracy, and also the market is still of a closed market economy, because that's how we have grown up, that's why we have grown up. Perhaps 1 or 2 generations down the line, the alignment of the people, the stakeholders, with the free market law would be from the day one, because that's what they have grown up in. But we are implementing a law which clashes with our many ideas Again, it's a separate debate. I don't want to talk too much about it. This is something which we need to study in detail. So therefore, while of course we are hoping that in these implementation many changes that are sought to be addressed will get addressed, but it is actually the behavioral economics that has to really be the focus for the next 5 years in terms of educating our people, in terms of understanding the psychology of the people, and also see how it complements the application of law. We all know that only 4 or 5 items that I'll mention in the implementation, which are the headline items, although there are plenty. The first is that it seeks to address some of the concern that had arisen from some of the judgments of the Supreme Court. Rainbow, Vidarbha, Prabjit Soni. And that was long overdue. By providing that security interest means only that has been created by way of documentation between the parties and not by operation of law. What it also does is, because it was realized that the implementation of the plan, we were facing many challenges where the inter-se dispute between the creditors was stalling the approval of the plan, implementation of the plan. Therefore, now a provision has been made where the lenders so agree that there are certain tensions between this set of the creditors. They can, by 66%, agree that the resolution plan can be approved by the NCLT if the plan is otherwise compliant with the law. But the inter-se issues can be parked and they can be decided separately again within the timeline that is prescribed in the code, in the bill. Which therefore means that the successful resolution applicant will be able to deposit the money promised in the resolution plan, get control of the company. He is out, he can start focusing on the turnaround of the company. Inter-se disputes can be resolved. At least they will not impact the value of the assets or stall the implementation of the plan. That asset goes back to the economy, is now contributing to the GDP already. It also adds to very unusual provisions. We've experienced that how many stakeholders, especially the government authorities, do not implement the resolution plan or honor it or recognize those provisions in the plan, even though they were specifically mentioned and approved by the NCLT in section 31, always provided that is binding on the various stakeholders, including the central government and the authorities. So therefore now 2 provisions had been added in section 31 to make it explicit that you can't insist on anything in relation to the past. You have to, whether it's sanctions, licenses, permissions, honor them. Of course, whatever obligations the resolution applicant has in respect of keeping them alive for future, you'll have to do it. And also it's that all litigations will be extinguished, which was always understood as it was specifically provided. But that has also been mentioned because we saw that experience was that many litigations continued despite the fact that the resolution plan provided otherwise. So many such similar provisions have been added in order to address the gap. For admission, it has been stated now that if it is not admitted within 30 days, you will give the reasons. Similarly, in respect of other areas of obligation of NCLT where timelines are provided, if you do not pass the orders within the timeline, you have to give reasons. I don't know how effective that would be, because we all know Surendra Trading judgment of the Honorable Supreme Court, where it has been held that these are directory, and rightly so. And as far as the providing reasons are concerned, I think that's going to be very simple. NCLTs are going to completely shift the onus on the lawyers if they're asking for time. And hopefully they'll start imposing cost also on the parties which are seeking unnecessary adjournments. But it's hard for the courts to often decide the matter within 14 days. A reasonable time, yes, but 14 days was always considered to be unrealistic timeline. That's another reason why the Honorable Supreme Court also felt that this is not something which you can really impose as a mandatory provision. Now the third bucket. The third bucket is what I term as a response to market failure. And I'll give you one example. Liquidation. liquidation is traditionally understood to be a matter between the court and the stakeholders through a liquidator, which is the agent of the court. That's the inherent principle of liquidation globally. Liquidation, or there is hardly a jurisdiction where there are committee of creditors in liquidation process. It's always been done under the supervision of the court, and an agent or extended arm of the court as liquidator acting on the instructions of the court. In fact, in winding up, as you knew, that 60% of the work was done in chamber of the judge on the administrative side. That's the inherent approach of liquidation worldwide. Now, but why did we need to introduce COC? That was for the reason that the market did not behave with responsibility, and liquidators did not conduct themselves up to the mark. Initially, we did not even have the concept of stakeholders consultation committee. It was still not there in the legislation. That was introduced 9 to 10 months after the IBC was implemented. I remember a round table that was held in Bombay, where Dr. Sau, who was then the chairperson, all whole-time members were there, top leadership, banks, IPs were there, which, IBB had requested me to organize, and it was there that we all agreed that there was a need to have some representation of the committee, of the creditors in the liquidation process, which will supervise the conduct of. But the experience, even after having introduced that provision and strengthening it, has been that unfortunately the liquidators have not been very transparent, and they have not been able to earn the confidence of the lenders and the regulators and the policymakers. And as a result of that, the policymakers had to step in and introduce the concept of committee of creditors. And that's why I call it where the market fails to self-regulate itself, fails to self-discipline itself, you will always find policymakers stepping in, the regulators stepping in to discipline you or to regulate you. This is exactly what has happened. And liquidation, where we could have actually shown and proven and made out a case for self-regulation of the profession, we are disappointed. And therefore, I think, I just want to give an example. I don't want to go into the whole concept of liquidation because I'm on the principles. But the fact remains that liquidation is a different ballgame from now onwards. If the bill is approved by the parliament, you'll have the committee of creditors with the power to appoint or remove the liquidator, something that was always the power of the NCLT. You will now have COC playing a very hands-on role, although it is still a supervisory role as it says, but the fact remains that they would drive the process. So the powers of the insolvency professionals now are also getting shrinking even in the liquidation process. Now these are some of the examples. Now I'm going to spend next 5-7 minutes on the fourth bucket, which is some of the concerns that I have from the bill. Now there are two major. The first is the provisions with regard to the withdrawal of the resolution plan. The Section 12A was introduced in order to provide a window to the lenders to settle the matter with such promoter who was willing to stay honorable. In the first 4-5 months of the implementation of IBC, many such applications for settlement were made. NCLT said we don't have the jurisdiction. NCLT said we don't have the jurisdiction. Ultimately, in Article 142, the Supreme Court approved that. And in having tired in one of the judgments, Justice Nariman then mentioned, we can't do this forever. If there are genuine cases where withdrawals should be done, why not make a policy provision? That's how Section 12A was introduced. Section 12A is again another debtor in possession concept, where the debtor is willing to correct his wrongs, is willing to comes forward to ask a second chance, and he says, I'm going to pay you a reasonable amount, much more than what you will get in the process of resolution. Give me a chance, and the lenders are willing to give that chance. Why not? That is what Section 12A is all about. But Section 12A also has been abused in the last 4-5 years to delay the process, obstruct the process. As a result of that, policymakers were concerned that this leverage that has been provided has been abused and we need to correct it. Fair enough. But my concern is that the window has been reduced to so small that it is almost to an extent of impossibility. Just fine. Because what now it says is, and if I have understood it correctly, that you can't make a Section 12A withdrawal application till such time the COC is formed, and cannot be made after first Form G has been issued. Often, in an efficient case, going by the timelines as provided by the IBC in regulation itself, once the COC is formed, the Form G would invariably be presented in the second meeting, because there's a timeline that is formed. So you're looking at about 15, 20, 30-day window. Now, who would be able to muster that kind of support from the 90% of the COC in such a short period of time, especially where the volume of amount involved may be very high? So in my view, this actually becomes an impossible clause, and it deserves to be reconsidered. If we have a 12A provision in the IBC, then it might as well be something which people can actually make use of. Of course, not abuse that, but to have a provision which is then almost like an impossibility serves no purpose. The other concern I have is on one provision with regard to the avoidance. Most of the changes that have been brought in with regard to the avoidance are those that provide clarity on the process, because various NCLT judgments had said different times, and there are judgments of the High Court, various Supreme Court judgments that have come over the last 5-6 years, and therefore we needed clarity. And I'm so happy to see that clarity coming in the form of various provisions in the bill. But what it also says in the meantime is that if the RP fails to file an avoidance proceeding, the lenders can, and fair enough, why not? Lenders should. In my view, lenders always were competent to file, even if there was no substantive provision in the code enabling them. But what bothers me is a provision which says that if the NCLT finds that the RP had failed to do its duty of filing, then they can recommend a disciplinary action. I mean, that's something very unusual in a statute. In my view, it is a very unusual provision, because fact remains that IBBI in any case has the power to initiate a disciplinary proceeding against an RP who's found to have neglected his duty to initiate himself. Now, but it's not that language or the provision that bothers me as much. What bothers me is today, the consequence of that would be that every RP will file an avoidance application whether there is a transaction audit says there is no transaction or not, because he won't take a chance. He will say, why should I unnecessarily expose myself to the risk? I will file it whether there is ultimately found to be a transaction which is avoidable or not. And we will end up burdening NCLT with a huge amount of cases. There will be a drain on the resources, limited resources of the NCLT, and ultimately a cost also, a cost that will have to be borne by the lender, by the taxpayers, because eventually the public institutions functions on taxpayers' money. In my humble understanding that this probably may not really be the right approach to ensuring that the insolvency professionals continue to stay diligent in terms of performing their tasks in respect to the avoidance transactions. Even today, in fact, most of them file avoidance transactions application any which ways. But now, they will ensure that they file it. So, this is the fourth bucket. And I'll just take 2 minutes to conclude my comments, as I started by saying in the beginning. In my view, this is the fifth thing that I wanted to talk about, is the sum of these four. That what this bill does is, it actually sends a very powerful message to the global community that India means business. Two, it sends a very powerful message to the Indian community, to India in the financial sector, that the political will behind the IBC is intact even today. And the concerns that in the last 2-3 years nothing is being done, why things are slow, are now answered. The third, it will create fresh energy into the IBC system, and hopefully the banks will come forward now to start initiating bigger cases. 4, it will send India up in the ranking on Be Ready, which is the new global ranking which the World Bank has issued, the Business Ready, because on that we were sitting on the fringe as far as the cross-border is concerned. And finally, I think what it will do is it will help open the doors for India to walk the path to becoming a developed country by 2047, because insolvency law, a vibrant, dynamic, robust insolvency law is very critical in supporting the economic growth. And this, in my view, will and should be viewed from that perspective and not just from the micro level of seeing what implementational issues we have introduced. It has a much greater objective to serve, much more powerful message to be taken away from, and I do hope that it will be implemented, passed by the Parliament as soon as possible and implemented soon thereafter. Thank you so much for your attention.